Hello everyone, very warm welcome to StudyIQ IAS English, your favorite channel, and I'm your educator Praveen Mishra. Today, going to discuss about the defamation case that has been filed against Rahul Gandhi. So, what has happened in 2020 after the Galwan Valley clash between India and China, where it was a very tragic incident for both the sides. Obviously, whenever a soldier's life is lost, obviously, it's not a very good news. But yeah, India fought a very brave battle, and yes, we provided a befitting reply to China. But what has happened after the Galwan Valley clash? Some people started taking political mileage. Okay, obviously they were not entitled to do so, but still they did. In 2022, one such person, Rahul Gandhi, as you can see on the screens, while performing the Bharat Jodo Yatra, while going ahead with the Bharat Jodo Yatra, he quoted something which was really not admissible by any Indian, at least by any nationalist Indian, if you are. What he quoted while the yatra, that is, while the march, as in that 2,000 square kilometers of the Indian territory is occupied by China. Apart from that, they have thrashed our Indian soldiers. He made the statement in Hindi कि 2000 किलोमीटर 2000 स्क्वायर किलोमीटर की जमीन भारत की चाइना ने छीन लिया और हमारे सैनिकों को दौड़ा दौड़ा कर मारा, कुछ इस तरीके से, exactly words I don't know, but yeah, something like that he stated. Okay, that they thrashed the Indian soldiers. See, this is a statement you can't give, specifically when you are holding a political position, and that too, right now, you are the opposition leader as well inside the parliament, that is in the Lok Sabha, basically. Right. Though the statement which was given by Mr. Gandhi, it was in the year 2022, where at that time he was not holding any kind of the government, constitutional, or any kind of the parliamentary position. He was just a member of parliament, and he was not even the leader of opposition at that time. Right. So, what is this? The whole news once again. Recently, that is just yesterday, August 4, 2025, what Supreme Court has given Rahul Gandhi some relief. That is, all the proceedings against him in the criminal defamation case has been stayed. Well, why is Supreme Court protecting Rahul Gandhi here? Is Supreme Court right? Is Rahul Gandhi right? Or the petition filed by the petitioner, that is wrong as well? So these are multiple questions that we need to address. Okay, but yes, obviously these are more political things, so let's refrain from discussing those things, right? But yes, the question here is, after the 2020 Galwan Valley, okay, the concern here is, after the 2020 Galwan Valley clash in 2022 during the Bharat Jodo Yatra, Rahul Gandhi, he took some words which was very much defamatory against the Indian Army. And now the features: the freedom of speech. Yes, as per Article 19, Clause 1, Subclause A, we have got the freedom of speech and expression. We can speak anything as we want. But you have to remember that there is also something known as doctrine of reasonable restrictions. As per the doctrine of reasonable restrictions, your fundamental rights are not absolute. Your fundamental rights are not sacrosanct. The state can impose reasonable restriction at a time whenever needed on them. They can be even suspended at the time period of martial law, or even when the imposition of national emergency is going on. Right? And yes, also, if there is no such emergency or martial law undergoing, it is not in operation, then also on the grounds of public morality, law and order, peace and tranquility things, your fundamental rights could face some reasonable restrictions. And also when it comes to the life and liberty as well as the dignity of an individual, group, organization, institution, class, caste, community, sex, etc., then also your fundamental right to speech and expression could be curtailed. It could be restricted. So what is this? Okay, this is doctrine of reasonable restrictions. Though this doctrine is not implicitly or explicitly defined anywhere in our constitution, but we have derived it through Article 19, Clause 2. What says? Okay, as you can see, Article 19, Clause 2 permits reasonable restrictions in this right, as in Article 19, Clause 1, Subclause A, as in freedom of speech and expression. Okay, in the interest of what? In the interest of, among others, sovereignty and integrity of India, the public order, as well as any kind of defamation. Remember, right to life and personal liberty under Article 21 also ensures the life with dignity. So you as an individual, you cannot give on those statements that is defamatory and that is also providing questions onto the dignity on others, the dignity of others. Specifically, yes, this is what the Constitution itself has mentioned. You cannot speak against anything. Okay, you cannot speak anything against the defense forces of the country, as they are our lifeline only. Because of them only, we are here. So we need to show the utmost level of respect to the soldiers. Okay, may it be the BSF, may it be the army, may it be the naval forces or the air force or whatsoever. If they are the soldiers, you have to show them the respect, and this is what is mentioned in the constitution itself under article 19 clause 2, right? Now, the reasonable restrictions, okay, when we talk about the freedom of speech and expression. So as you can see, the criminal defamation thing is also mentioned in IPC under section 499 and 500, which is explicitly upheld as reasonable restrictions by the Supreme Court, balancing the reputation and the free speech. Right? So remember, if you are going ahead with the free speech, you have it under Article 19, Clause 1, Subclause A. But remember, under Article 19, Clause 2, you also have the you also have the doctrine of reasonable restrictions. And yes, if you try to defame any person with your words, with your speeches, with your voice, with your writings, with your drawings, with your expression, anything, then remember Section 499 and Section 500 of the IPC is there to punish you, right? So here we go. The landmark free speech judgments, okay? So for the first thing, we have got the Ramesh Thapar versus the State of Madras case 1950. So as per the provisions of the case that you can see, the first major ruling striking down a Madras government order banning the weekly crossroads, holding that freedom of speech includes freedom of propagation of ideas and the liberty of circulation, subject only to the limited exceptions under Article 19, Clause 2. So literally, your freedom of speech and expression also includes the freedom of propagation of your ideas, no doubt in that. But remember, you cannot literally, you do not and you cannot intervene into the propagation, into the ideas, into the liberty of others. So remember what it has been always stated: my rights are your duties. Right? My rights are your duties. The next, we have got the Shreya Singhal case, which we have already discussed multiple times on our same channel. Guys, stay tuned with the comment section, right? So in that comment section, we are going to pin this class link as well, the Shreya Singhal versus Union of India case of 2015, under which the Supreme Court struck down Section 66 capital A of the Information Technology Act of 2003, right? So where Supreme Court stated that the chilling effect is literally very much disturbing as well as unconstitutional, and it is literally not protected under Article 19 Clause 2, that is freedom of speech and expression. Through the 19 Clause 2, that is through the doctrine of reasonable restrictions on the right of freedom of speech and expression, right? So guys, remember what you need to watch is the Shreya Singhal case, okay? Shreya Singhal versus Union of India case 2015. I have only covered that video, okay? I've only covered that section, basically that case in a separate video, and for which you can just watch out for the pinned comments and you will find the Shreya Singhal case video there, okay? Then finally, we have got the Subramaniam Swamy versus Union of India case, wherein a two-judge bench upheld the criminal defamation under Section 499 and 500 as constitutionally valid, recognizing the right to reputation under Article 21, okay, guaranteed with the name dignity. Okay, you cannot just keep on going and speaking and blabbering anything against the dignity of any individual, organization, or anything. Right? Okay, so guys, remember the three major cases in front of you: Ramesh Thapar versus State of Madras 1950, Shreya Singhal versus Union of India 2015, and Subramaniam Swamy versus Union of India case 2016. So these are the three major cases related to Article 19 Clause 1 Subclause A and the reasonable restrictions mentioned under Article 19 Clause 2. And all of these cases references have been used into the present Rahul Gandhi defamation case as well against the Indian Defence Forces. Right? Now, the criminal defamation under the IPC, as we've already discussed, Section 499, that talks about what actually is defamation, and Section 500 that says if a person is proven to have shown any kind of disrespect or a direct attack against the dignity of an individual or an organization as well, then he or she could be prosecuted or could be jailed up to 2 years and a fine as well, or even both, for any kind of defamation, right? So this is where Supreme Court has already stated. The Supreme Court in this case reaffirmed that such provisions are, yes, reasonable restrictions under Article 19 Clause 2. This is what Supreme Court's affirmation has been. Next thing, role of the opposition. See, what our politicians need to understand, what Supreme Court has also stated, and what the senior advocates during this case hearing has also stated. Okay, Opposition's democratic function is to hold the government's accountability and also raise issues of public concern, right? Even if these are the inconvenient ones, this is what the role of opposition is, to hold the accountability and answerability of the incumbent government as well as raise the serious public issues. So during the hearing, Advocate Abhishek Manu Singh, what he quoted, he argued that barring an opposition leader from expressing views in the public domain undermines parliamentary democracy, okay, as well as their debate rights, but for which Supreme Court has got a different opinion. The court's insistence, okay, the court stated that such serious allegation be brought up in parliament rather than on social media. So what Supreme Court stated, that if Mr. Parliamentarian was having some issues, he should have raised that issue inside parliament rather than quoting it publicly and ultimately drawing some serious legal troubles for himself. So for this we have got Article 105 and Article 194 for our MPs and MLAs respectively. As per the constitutional provisions of Article 105, anything stated by parliamentarians inside parliament, may it be in the Lok Sabha or Rajya Sabha, okay, you cannot try or prosecute them for anything quoted by them inside parliament. This is what Article 105 has to say. Okay, so this literally grants the MPs immunity from any kind of civil or criminal liability for anything stated by them, okay, inside the parliament, any speeches made by them inside parliament, any votes cast by them inside parliament, or any type of committee discussions inside parliament only. So what Supreme Court stated, Rahul Gandhi must have utilized his parliamentary privileges granted to him under Article 105 Clause 1 as well as under Article 105 Clause 2, that no member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him or her in parliament or any committee thereof of parliament itself, right? Okay, so he should have quoted this thing inside the parliament if he was so much concerned that 2000 square kilometers of the Indian territory is now occupied by China and they have thrashed our Indian soldiers as per his statement. He should have quoted this thing inside parliament, what the opposition leaders and the members they are doing inside parliament regarding the present ongoing operations of the government as well as the forces, right? So that's valid. They can do so. They can ask the questions. They can raise the questions inside parliament and they are having this immunity. They can do anything. There is no reasonable restrictions on them inside parliament only. And this is what Supreme Court stated, that if Rahul Gandhi was having so much of problems, if he was concerned about 2000 square kilometer of the land, though hypothetical, okay, but still he was in case concerned, he should have quoted all of these things inside parliament as he has got the immunity there, right? But no, he took the other way. He took this, into the public domain, and so he called himself for some legal serious troubles, right? So for this we have got some case references as well, that is named as the Keshav Singh case as well as PM Narasimha Rao versus the state, that is known as the JMM bribery case, right? So what are these two cases related to Article 105 only? Guys, remember, these are both the cases related to Article 105. So, Keshav Singh case of 1965, the privileges case held that parliamentary privileges, they are subject to judicial review. Okay, though you have got utmost level of parliamentary privileges, no doubt in that, but all of your parliamentary privileges are subject to what? Judicial review. And then we have got the Prime Minister PV Narasimha Rao, the then Prime Minister PV Narasimha Rao case of 1998. Okay, popularly known as the Jharkhand Mukti Morcha bribery case. What happened? At that time, Narasimha Rao's government was, facing a no confidence motion. Okay, the judgment came in 1998. The case is of 1991 or 92 basically. Right? So the PV Narasimha Rao government was facing no confidence motion inside the parliament. And as per the allegations, remember, this is what the allegations, okay? Some 4 or 5 MPs of Jharkhand Mukti Morcha, they were bribed to vote against the PV Narasimha Rao government, okay? Now, all of these things, these came out into the public domain. The public got to know through the news articles, and immediately the CBI probe started. And the moment CBI probe started, the CBI in its investigation, they found that yes, the allegations are right. There have been 4 or 5 MPs, okay, sitting MPs of Jharkhand Mukti Morcha, those who were bribed, and they voted against the Narasimha Rao government as well. But still, the Supreme Court was not able to take any action as the MPs' concern, as the MP's statement was. Whatever they did under Article 105. Even if they were bribed, see, the corruption was constitutionally saved. Even if they were bribed, okay, but still they made their vote, they cast their vote through this Article 105. And casting vote inside Parliament also provides the immunity to the sitting MPs inside the Parliament. So even if they are bribed, it's okay, no worries. Okay, they have taken the bribe, they admitted it, but yes, they casted their vote under the provisions of Article 105 only, and hence the Supreme Court stated that yes, they did whatever the Constitution told them. Though they took the bribe, which is unethical, but yes, their bribery and their parliamentary privileges, okay, are nowhere correlated with each other. So Supreme Court ruled that Article 105 Clause 2 gives the immunity to MPs for any vote or speech inside Parliament, even if they were allegedly bribed to do so, right? So this is what the most constitutional humor is, right? Even if you are bribed and then also you have voted, but it's okay. You are immune under Article 105 Clause 2. Right. Okay, guys. So please remember, this is it with regard to this topic. And if you're a serious UPSC CSE aspirant, guys, remember what we have got. We have got for you the resolution batch that is about to commence from 8th of August with 1,000 plus hours of live classes, access to recorded lectures, 18 plus books given to you at your doorstep, the class notes immediately in the PDF format at the end of the session, 75 plus tests for your prelims, 15 plus tests for your mains, and multiple mock interviews with regard to your interview guidance program, 1:1 mentorship, as well as the mains residential program. All of these things under one single subscription known as the resolution batch. So guys, remember, it is for the students, those who are targeting the exam year in 2026, right? So if you're a serious aspirant of 2026, right, and you want a proper guidance, proper notes, proper books, proper mentorship, proper teachers, and proper educators, so you know it very well, StudyIQ has got you covered. So from prelims to mains to interview, just one name once again, StudyIQ. So this is the GS Foundation batch, guys. This is the August batch commencing in the next 3 days. So you have got just 72 hours to enroll into this August batch. 8th of August, the classes shall be commencing. So guys, quickly enroll yourself here and let nothing come between you and your success. So guys, remember, along with the books, along with the notes, you have got the test series, the prelims test series, the mains test series, the interview guidance program, as well as the mains residential program as well. Everything under one just single subscription, and the subscription plans, they are of multiple types like gold, platinum, and diamond, and the prices, they are starting with just rupees 9,999 only. All of these things, okay, prices are starting, the subscription plan starting with just rupees 9,999, and you'll get the maximum possible discount only if you get this promo code. So guys, what is this promo code? It is PRV Live. Okay, so use this promo code, okay, and get the maximum possible discount on every subscription you purchase on the StudyIQ platform. So guys, remember, PRV Live is the promo code you guys are going to use, and in case you have any doubts, you can connect with me on my Telegram channel for the class links, notes, PDFs, and all other important things. Okay, so here is the Telegram channel, Praveen_StudyIQ, and in case you want to have any further discussion, you can also connect with me on my Instagram channel, that is Praveen Mishra_2107. Okay, so this is the QR code for the Telegram channel. You can just scan it and connect with me here. And apart from that, okay, this is the Telegram Instagram account as well. And guys, please, before you leave, don't forget to hit the subscribe button of the StudyIQ IAS English, a channel dedicated and committed to provide you all the quality and quantity of the content. So guys, hit the subscribe button and never miss an update from the channel. See you in the next session. Bye bye. Good day. Take care. Jai Hind. Jai Bharat.